3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through Alexander Acosta and tested what the records could actually prove without speculation. Today, we are examining the sweetheart deal and mapping what the documents show about actors, timeline, decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is the September 2007 non-prosecution agreement between the U.S. Attorney's Office for the Southern District of Florida and Jeffrey Epstein, which detailed the specific terms. 13 months in a county jail with work release and registration as a sex offender.
And that document is our anchor point for this entire audit. We have to establish the baseline here.
Okay.
We aren't here to relitigate the morality. That's been settled. What we're doing is a forensic audit of that legal architecture from 2007-2008.
So comparing the text of the non-prosecution agreement, the MPA.
Right. The black and white clauses, comparing that against how the sentence was actually carried out.
Which we can track in the jail logs and other records.
Exactly. The goal is to separate the mythology, all the noise around the deal, from the statutory reality.
The reality is actually documented in the Southern District of Florida files. We're looking for the anomalies.
That's the mission, an audit of anomalies. And it all begins with that primary source you mentioned, the September 2007 non-prosecution agreement.
It really is the Rosetta Stone for this whole thing.
It is. Everything that comes next, for more than a decade, the silence, the civil suits that went nowhere, the lack of arrests, it all flows directly from the specific wording on those pages.
So let's start with the first major anomaly, the federal concession. When you read the text, it's just staggering what the federal government gave up. There's a specific clause.
The one where the United States agrees not to institute any criminal charges.
Yes, against Epstein for the findings of their own investigation.
This is the critical pivot. You have to understand what a huge deal this is. This was an active FBI investigation.
Not just a preliminary inquiry.
No, not at all. They'd raided his Palm Beach mansion. They had seized computers, hard drives. They'd conducted interviews with victims. They were building a case based on the Mann Act.
Which is about transporting people over state lines for illicit purposes.
For illegal sexual purposes. It's a heavy-duty federal statute. It's what the FBI was created to enforce. It carries serious prison time.
And when the feds have a Mann Act case, they prosecute it.
They prosecute it. They don't typically hand it off to a local DA to handle a misdemeanor solicitation charge.
Federal jurisdiction almost always supersedes state-level charges, especially when you have interstate travel involved.
Correct. But this document, the MPA, it just shuts the whole thing down. It takes a powerful federal case with all the resources of the FBI, and it localizes it.
It says, we, the United States government, are standing down.
That's precisely what it does, and it kicks it down to the state level. The document dictates that Epstein must plead guilty to state charges.
And not even the most serious state charges available.
No. Solicitation of prostitution and procuring a minor for prostitution.
That's a massive de-escalation of legal liability.
It's night and day. You go from facing potential decades in federal prison for sex trafficking
to state charges that carry much, much lighter sentences. The terminology itself changes the perception.
It does. Solicitation sounds like a vice crime, a transaction. Trafficking, the federal charge, implies coercion, force, fraud. By changing the venue and the words, the MPA fundamentally changed the crime in the eyes of the law.
The NPA also mandated he register as a sex offender.
Right, and that was the win that the prosecutors, specifically Alexander Acosta's office, always pointed to.
They argued that getting him on that registry was the #1 priority, and this deal guaranteed it.
We'll get into their internal justifications later on, but if you're just looking at the legal structure, this is highly irregular, a federal MPA dictating the specific outcome of a state-level plea.
It's just not how it's done.
It's rare. It suggests an extremely high level of coordination, almost a partnership, between the U.S. Attorney's Office and the local state attorney's office.
These are offices that usually operate in their own lanes.
Right. Here, they seem to be working lockstep to build one very specific, very unusual outcome.
And we're not the only ones who found it unusual. Years later, you have to look at the 2019 order by Judge Richard M. Berman.
From the Epstein case documents.
Berman, a federal judge in New York, reviewed these exact terms when the case was reopened. And you can see it on the transcripts, he was basically baffled.
He was baffled by the sheer scope of the immunity and the architecture of the deal. His review really highlights just how far outside the lines this agreement was.
He noted that it bound the Southern District of Florida, but the way it was written, it was an attempt to bind the entire federal government everywhere, forever.
It was a document designed to be a fortress, to close every door, lock every window, and bury that FBI investigation so it could never be revived.
You read his comments in the court record, and the subtext is just, how on earth did this get signed?
A question a lot of people were asking.
Okay, so let's move to the sentence itself. Public perception, and a lot of the reporting at the time, always uses the number 18 months.
Right. 18 months. That was the number you saw in every headline.
But when we test the record, when we look at the verified NPA text and the plea documents, that number, it's not the reality of his confinement.
It's the sticker price, not what was actually paid. The NPA recommended a sentence of up to 18 months, but the plea deal itself and the way the Florida county system works,
it was never going to be 18 months.
Never. And the type of facility is a crucial distinction here. The agreement specifies county jail.
Not a federal penitentiary, not even a state prison.
He was sent to the Palm Beach County Stockade.
What is the stockade exactly?
It's a minimum security annex. It's for people with DUIs, nonviolent misdemeanors, low-level offenders. It is absolutely not designed for a suspect in a federal sex trafficking investigation.
So the conditions are different.
Completely. And if you look at the notice of filing transcript and the plea documents from 2008, we can verify the exact timeline.
The actual duration of confinement.
We can calculate it. And when you factor in gain time, or what some systems call good time credits,
which are automatic reductions for not causing trouble.
Right. In that county system, those credits are significant. The math shows he was released after serving roughly 13 months.
So the 18-month sentence was, in reality, a 13-month sentence from the moment the ink was dry on the plea.
Correct. And even the word served needs a huge asterisk next to it when you look at the conditions of that confinement.
Because if you or I get a 13-month sentence, we're in a cell. 2-7.
We're wearing a jumpsuit, eating prison food, living under constant supervision. That was not the case here.
Which brings us to the next evidence block, the work release architecture.
This is where the deal goes from unusual to almost unbelievable. You have to look at the Palm Beach Police Department and Sheriff's Office logs.
These were later referenced in the House Oversight Epstein Files.
Yes, and these logs are the daily accounting of his movements. They show what incarceration actually meant for him.
The logs document that he was released from the stockade for up to 12 hours a day.
6 days a week.
6 days a week.
It's not jail, it's a commute. He would sleep at the stockade, then check out in the morning, often around 8 a.m., and spend the entire day at his private office.
And return in the evening.
Correct. This wasn't a standard work release program.
Not at all. Those are usually for, manual labor jobs or so someone can keep their job at a factory to support their family.
Exactly. It's a program designed to stop the families of low-level offenders from falling into economic ruin. It is not designed to allow a multimillionaire to continue managing his financial empire from a private office.
And what kind of supervision did he have during those 12-hour days?
The logs show occasional office visits by sheriff's deputies, but they were infrequent, spot checks at best. For the vast majority of those 72 hours a week, he was unsupervised in his office.
With his own staff?
With his staff, his phones, his computers. The Palm Beach Post reported at the time that he was holding meetings, conducting business. He was living his normal life during the day.
So the deal didn't just reduce his sentence, it fundamentally changed the quality of the confinement.
It preserved his entire operational infrastructure. Think about it. A real federal sentence would have cut him off from his network. His assets might have been frozen. His communications would have been monitored and restricted.
But the Stockade Plus work release model?
It kept the machine running. It allowed him to maintain his business, his connections, his power. The disruption was minimal.
And this wasn't something that just slipped through the cracks. People in law enforcement knew this was happening, and they objected.
This is one of the most critical documents in the entire case file. The letter from Michael S. Ryder to Barry E. Krischer.
Dated May 1st, 2006. So well before the final deal was signed.
A year and a half before. Ryder was the chief of police for Palm Beach. His department was the one that did the initial investigation. His detectives were the ones who raided the mansion and took the victim statements.
And he wrote this letter to the state attorney, Barry Krischer, basically putting a formal objection on the record.
We should quote this directly from the letter. Ritter writes, quote, "I continue to find your office's treatment of these cases highly unusual."
In the world of bureaucratic, interagency communication, highly unusual is a fire alarm.
It's a scream, yes. Ritter was a career cop. He knew how a case with this much evidence was supposed to move forward. He had probable cause affidavits, he had witnesses, and he's watching the prosecutor's office pivot towards a resolution that just doesn't fit the crime.
He also writes, "I urge you to examine the unusual course that your office's handling of this matter has taken."
He's documenting his dissent. He's creating a paper trail. And this letter, it completely destroys the later narrative that, everyone agreed this was the best possible outcome.
Because it proves the opposite. The local police, the boots on the ground who gathered the evidence, were against this deal.
They wanted a standard prosecution. They wanted to see Epstein face the felony charges they had worked to build. The friction between the Palm Beach PD and the state attorney's office is there in black and white.
And that timeline is so important. The letter is from May 2006. The MPA isn't signed until September 2007.
That's a 16-month gap. For 16 months, the lead investigator on the case is on record saying something is wrong here, and the prosecutors just kept moving forward with the deal.
Rader's letter even mentions that his detectives' phone calls to the prosecutor's office weren't being returned.
They were being frozen out. The state attorney's office built a wall around the case, effectively excluding the very investigators who brought it to them. They took control of the outcome and silenced the dissent within law enforcement.
So we have a federal investigation halted by a federal MPA, a state plea that's condemned by the local police chief, and a work release program that turns jail into a dormitory.
But there's another piece of this MPA, a clause that is arguably the most consequential and controversial part of the whole agreement.
The immunity clause.
Or the co-conspirator clause.
Yeah.
If you go back to the text of the Jeffrey Epstein non-prosecution agreement, there is language in there that is just breathtakingly broad.
It grants immunity not just to Jeffrey Epstein.
No. It grants immunity to any potential co-conspirators.
Any potential. It doesn't name them.
That's the key. It's a John Doe immunity clause. It doesn't list the people being protected. It just throws a blanket of immunity over anyone who could potentially be considered a co-conspirator in the federal investigation.
How does that work legally?
Usually, immunity is a specific tool. You grant it to a specific person for a specific reason.
It's transactional. You give immunity to a smaller fish to get them to testify against the bigger fish.
Right. You give me the boss, you walk. This inverted that whole model. The boss got the deal, and his deal included immunity for everyone who worked for him. It means that anyone who might have helped Epstein recruiters, schedulers, pilots, financial people could now claim they were protected by this federal agreement.
And we have documentation that this is exactly what happened later on.
We do. In the file release from the civil case, Giuffre versus Maxwell, you see this play out.
Ghislaine Maxwell.
Her defense attorneys, in both the civil suits and later in your criminal case, they pointed directly back to this 2007 NPA.
They argued that she was a potential co-conspirator and was therefore immune from federal prosecution.
It was a central pillar of her defense for years. This one clause in this one deal from 2007 was being used as a legal shield a decade later. It turned the MPA into a global pardon for the entire Epstein enterprise.
A pardon that was granted in secret.
In secret, from the people who mattered most. The victims. This is the Crime Victims' Rights Act violation. The CVRA.
And we have a House Oversight Committee document that details the filings on this.
Yes, and the law is clear. The CVRA requires federal prosecutors to notify victims about plea agreements and non-prosecution agreements. It gives victims the right to be heard, to confer with the government's attorneys.
And in this case?
That didn't happen. The 2019 court ruling, the one that finally found the government had violated the law, confirmed it. The victims were not notified before the MPA was signed.
So they signed the deal, granted Epstein and his co-conspirators immunity, and the victims had no idea.
None. They found out after the fact is a done deal. And that 2019 ruling confirmed the violation, but the judge struggled with a remedy.
Because the deal was already over a decade old.
You can't unring that bell. The damage was done. The immunity had been granted and relied upon. It was a massive procedural failure with devastating real-world consequences.
It denied them their day in court when it mattered. And it went beyond that. They were essentially being misled. They believed an investigation was still active while, behind closed doors, the prosecutors were finalizing an immunity deal.
So let's just take stock of what the documents prove so far. A 13-month actual sentence. A 6-day-a-week work release. Blanket immunity for unnamed co-conspirators. and a confirmed violation of the victim's rights.
Which brings us to the central question, why? What was the official institutional justification for a deal like this?
For that, we turn to the internal communications from the Pinpoint database and, more importantly, the Department of Justice's Office of Professional Responsibility report, the OPR report.
And that report investigated the conduct of the prosecutors, right? Alexander Acosta and his team in Miami.
Correct. And their internal justification, the story they told their superiors and the OPR investigators, boils down to one concept: risk aversion.
They said going to trial was too risky. They might lose.
They claimed the evidence was weak, that the victims, who were young women with troubled pasts, wouldn't be seen as credible witnesses by a jury.
And they were worried about Epstein's legal team.
Immensely. Epstein had hired a legal dream team. Alan Dershowitz, Ken Starr, Jay Lefkowitz. These were not just top lawyers. They were lawyers with deep connections inside the Department of Justice.
And the Pinpoint database shows they were aggressive.
They bombarded the prosecutors with legal briefs, white papers, arguing the feds had no jurisdiction, that the victims were unreliable, basically threatening to go to war and scorch the earth if the case ever went to trial.
So the official story is the prosecutors got scared and they blinked. They took what they saw as a sure thing, the state plea and the sex offender registration, rather than risk a humiliating loss in federal court.
That's the official justification. But it runs directly contrary to that letter from Police Chief Michael Reiter.
Because Reiter said the case was strong.
Reiter's letter explicitly states that his department's probable cause affidavits were sufficient for prosecution. The local cops who built the case, they weren't afraid of the defense team. They believed they had the goods.
So you have this fundamental disconnect. The federal prosecutors are saying this case is weak, while the local police are on record saying this case is strong.
And in that disconnect, you find what we can call the accountability gap. Because after all this, the OPR investigated and came to a conclusion.
And their conclusion was that the prosecutors exercised poor judgment.
That phrase is very, very specific: poor judgment.
It's a bureaucratic term of art. It's not professional misconduct.
Correct. Misconduct would imply corruption, or a deliberate violation of rules, or gross negligence. That could lead to disbarment, to being fired. Poor judgment is a slap on the wrist.
It basically says you made a bad call, but you were operating within your prosecutorial discretion.
And that was the final word. Despite all the anomalies, despite Reiter's warnings, despite the CVRA violation, the official conclusion was that no one committed misconduct. No one was fired. No one lost their license to practice law. The system protected its own.
The institution's response was to defend the institution. They admitted it was a bad deal in hindsight, but they maintained it was a legitimate exercise of prosecutorial discretion.
They circled the wagons.
Okay. We have to address the other theory, the one that hangs over this entire case.
The intelligence angle.
Yes. There are persistent claims that this sweetheart deal happened for a reason that has nothing to do with poor judgment, that it happened because Epstein was some kind of intelligence asset, that he was protected.
And here we have to apply extremely strict source discipline. There is a document, The Theory of Cover-Ups, by Jeff Pearson, that outlines this theory in detail.
But we have to be absolutely clear. We are classifying this as a theory document.
That is essential. It's an analysis of possibilities, not a government record. We have audited the official DOJ releases, the OPR report, the House oversight files. We have specifically searched for any government personnel files, payroll records, or official documents confirming Epstein's status as any kind of asset.
And what did that search find?
Nothing. We do not have documentation for that. The terms you hear associated with these theories, like Mossad or operational asset, they do not appear as a confirmed status in any of the verified government filings we have. Not in the NPA, not in the indictments, not in the FBI reports.
So to be clear, while the theory of intelligence involvement exists, the deal itself, as documented in the official records,
is documented as a legal and procedural decision. The files show powerful lawyers making a deal with government lawyers. They show bureaucratic maneuvering and institutional failure. They do not show a documented order from an intelligence agency saying, "Stand down."
That does not mean it didn't happen.
It means we don't have the documentation for it in this public file set.
Yeah.
And as auditors, we have to stick to what the documents can prove. The sweetheart deal, as anomalous as it is, can be explained by a combination of risk aversion, an overwhelming legal defense, and institutional cowardice.
You don't need a grand conspiracy.
Sometimes incompetence and fear are enough to produce a catastrophic result. A group of prosecutors wanted to close a difficult file. A high-powered defense team wanted to protect their client. A police chief's warnings were ignored, and the outcome was a profound miscarriage of justice.
Let's try to synthesize this. If we map the deal based only on these confirmed mechanics, what does the picture look like?
You start with a non-prosecution agreement. You add Chief Ryder's contemporaneous letter of dissent. Then you overlay the daily work release logs from the sheriff's office.
And the narrative that emerges from those documents
Is one of a deliberate institutional choice. The U.S. Attorney's Office for the Southern District of Florida made a conscious decision to prioritize a guaranteed but weak state-level plea over the risk and exposure of a federal trafficking trial.
And they made this choice even though they had been explicitly warned on paper by the lead law enforcement agency that their course of action was highly unusual.
That's the core of it. They were warned. They knew. And they did it anyway.
So the documents prove the what? We know precisely what the terms of the deal were. We know the mechanics of his confinement. We know who got immunity.
But the definitive why, that remains elusive. The motive for such extreme leniency, beyond their official explanation of risk aversion, is absent from the unredacted files.
The poor judgment explanation feels insufficient.
It feels insufficient to explain the sheer scale of the anomalies, but it is the only official explanation the documents provide. It leaves a logical gap. Why would a famously aggressive prosecutor's office fold so completely?
That's the question that hangs over everything. Was it just the pressure from the defense lawyers? Or was there another form of pressure? The files don't give us the answer.
But the result of that decision is not in dispute.
The result was that Jeffrey Epstein walked out of the Palm Beach County stockade after 13 months and resumed his life.
And for the next decade, he operated with the confidence of a man who believed he was untouchable. And the victims were left with silence.
That co-conspirator clause. The immunity. It's the part of the deal that had the longest legs.
It's the ghost in the machine. It lived on long after Epstein's sentence was over. It was a permanent get-out-of-jail-free card.
And for over a decade, the Department of Justice honored that contract.
They did, until the reporting from the Miami Herald and the subsequent public outrage became so overwhelming that another U.S. Attorney's Office, the Southern District of New York, was forced to take a fresh look.
But even then, the 2007 NPA was the first line of defense. They argued that the New York office was bound by the deal made in Florida.
A kind of double jeopardy argument. You can't prosecute us for this. Your colleagues already promised not to.
Yeah.
It took years of litigation for the courts to finally rule that the New York office was not bound by the Florida agreement.
So for more than a decade, the NPA worked. It held.
It worked exactly as its architects intended. It was an ironclad shield.
Which brings us back to that Raider letter. Highly unusual, that one phrase.
It's the anchor of the whole thing. It proves that someone in authority knew, in real time, that this was a deviation from normal practice.
It proves this wasn't just business as usual.
Yeah. And deviations from the norm, they leave a trail in the documents.
A trail that eventually leads to the names of the other people involved.
The ones who were never charged.
Because of the deal.
Because of the sweetheart deal.
Yeah.
And that immunity clause is the bridge to the next part of this story. It wasn't just about protecting him. It was about protecting the network.
Next time, the immunity list.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.